Did you know that in the US and in many countries around the world, the government can get your medical records without a warrant, access your photos without a warrant, see your contacts list, what you've watched, read, liked, where you've been, whom you've met, and what you did, all without a warrant?
It seems like we have lost the ability to have privacy in the digital age.
Arguably, we have.
How is this possible? How did we end up in a world where law enforcement can get access to all of the intimate details of our lives with seemingly no guardrails? The answer is because of something called the third-party doctrine. It's an archaic legal precedent in the US created by people who never foresaw today's technology, before the internet, before smartphones, before our messages, movements, relationships, and private lives migrated online and were turned into data. The consequences of the third-party doctrine have been catastrophic. This outdated principle helped erase the protections that were supposed to shield us from arbitrary government intrusion and opened the door to a potentially dystopian future of unchecked surveillance and control. In this video, we're going to unpack what the third-party doctrine is, what it means in a digital world, and why it needs to go. Now, to understand the third-party doctrine, we first need to do a quick recap of the Fourth Amendment.
The Fourth Amendment protects people's persons, houses, papers, and effects against unreasonable searches and seizures.
Jim Harper is a constitutional law scholar who specializes in the Fourth Amendment and how it applies in the digital age. And in our last video, he explained how it's supposed to impose strict warrant requirements to force law enforcement to slow down, justify itself, and face a judge before it's allowed to search your stuff. Which makes sense. We don't want those in power to have unlimited access to our lives, because that kind of access invites abuse. The whole point of requiring another branch of government to sign off on the intrusion first was to protect people and allow them to feel secure in their lives. But if that's how the Fourth Amendment is supposed to work, then how did we end up in a world where the government can buy data from data brokers, query companies' databases, and use private firms to search our lives without a warrant?
We are called to ask whether the Fourth Amendment is really still alive in the digital age.
It's because technology evolved and the courts and Congress didn't keep up. We're still using the outdated third-party doctrine to decide how much of our lives the government can access without a warrant. So what exactly is the third-party doctrine, and where did it come from?
The third-party doctrine is the idea in Fourth Amendment law that a person who has shared information with a third party has forfeited their right to control that information.
In other words, if you give your information to a company, you no longer have a reasonable expectation of privacy for that information. Fourth Amendment protections don't apply. It's a big legal loophole that lets officials get at your data without the safeguards that most people think that they still have. And it
grew out of a pair of cases in the mid-1970s that have little or no relation to how technology works today, but there they are nonetheless.
The first case we'll talk about was in 1976, called US v. Miller.
And it dealt with financial information. Miller was accused of running a distillery without paying taxes on it.
The government needed his financial records to prove that he wasn't paying his taxes. Things like bank statements, copies of checks that had cleared, etc. So
the government had gone to the bank and the bank had handed them over. And Miller challenged the use of those as evidence, saying that those were his papers and that the government couldn't get them without a warrant.
But the court disagreed. They said,
these bank records, they're the banks. They're not the customers.
Then came the case US v. Smith in 1979. Police wanted to confirm that a stalking suspect had been calling a woman, so
the government went to the phone company and said, we want to confirm that this is our guy. So will you look at your records and tell us who he's been dialing from his home?
Smith challenged the use of these records because the police didn't get a warrant.
And they said, no, this is the phone company's records, not yours. You don't have any privacy interest in this information.
These two cases became the basis for a much broader principle that once you share information with a company, you lose your Fourth Amendment protection over it. At the time, maybe it didn't seem like such a big deal. These were relatively narrow cases about bank records and dialed phone numbers involving specific suspects who were already under suspicion. But let's look at the logic behind this argument.
The problem with the third-party doctrine is that anything you knowingly expose to the public means that you lose all Fourth Amendment protection in it.
Rob Fromer is the co-director of the Fourth Amendment Project at the Institute for Justice, and he explained how this concept of sharing information has been stretched so far that it now means that if you want to participate in ordinary life, you lose constitutional protection over almost everything.
Obviously, if I'm literally just walking down a street and somebody sees me, I can't really complain about that. But it's been taken so far as to say, if you give medical information to your doctor, that's not protected by the Fourth Amendment.
Why does the logic get stretched this far? Well, because modern life routes everything through third parties.
If I send you an email, it doesn't go from me to you. It goes from me to Google to you.
Your email provider stores your messages. Your bank has your transactions. Your phone company has your location. Your cloud account holds your files. Your apps know where you go, what you search, what you buy, who you talk to, and what patterns your life follows.
Everything we do requires a third party. The entire internet runs on third parties. This is a really scary precedent to have in an era where our entire lives migrated into the digital realm.
It absolutely is. Everything, all this stuff. So your telephone calls, your text messages, health records. Think of all the things you upload to cloud service providers nowadays, all the transactions you do online, your conversations with loved ones. All of these are shared with third parties. The third-party doctrine says no Fourth Amendment interest.
The courts say that we voluntarily handed over this information and thus gave away our rights. But is that really true? So much of the infrastructure of modern life doesn't give us a choice.
Disclosing your personal data to third-party companies is basically unavoidable.
Use a bank, lose protection. Have a phone number, lose protection. Use the internet, lose protection.
With the huge swelling of information that's online in third-party hands, our privacy is undermined deeply by the third-party doctrine and the resistance to using warrants to get information when they properly should.
With warrants, law enforcement needed probable cause, a reason for intruding into someone's life, and a judge had to sign off first. Now, governments can often just go to companies and demand the data instead. They say,
We can go to Google and just demand to know where you were at any given time. So the third-party doctrine is a pretty big hole in our rights.
And increasingly, they don't even need to do that. They can just buy the data outright.
A new report from the Office of the Director of National Intelligence reveals the federal government is buying your data from data brokers.
Cops could not just collect cell phone location data without a warrant. So what did the government do to get around it? They started buying it in that exact same year from a brokerage company known as Ventel.
God, this is so frustrating. Shouldn't a Fourth Amendment search include any purposeful investigative act of someone, regardless of how the government got that data? Whether by querying a database, buying data from a broker, subpoenaing a platform, or scraping the web through a contractor, shouldn't that trigger the same constitutional scrutiny as any other search?
Once we say any purposeful investigative act is a search, now it's in the Fourth Amendment bucket. Now we can have courts actually starting to evaluate, well, what kind of search is this? How invasive is it? Is it something that would undermine the people's security if I just let officers do this whenever they want?
Instead, law enforcement have created all these carve-outs for themselves of things they don't consider a search. It's not considered a search if the information comes from your own database. Then it's just a database query. How did the term search get so squishy and malleable? I guess because when the Constitution was written, the only way to get someone's information was to barge into their house. But as technology evolves, our understanding of intruding into someone's life needs to evolve.
The court has always struggled with high technology. In the 1920s, it struggled with how to treat a wiretap. And in 1967, it dealt with a case where government agents had placed a microphone on the outside of a telephone box We used to, back in the old days, go and pick up a payphone inside of a glass box to talk with other people. We didn't have phones we carried around. The government had bugged one of these, and the court, struggling with this use of technology to gather information about people's communications, arrived at the reasonable expectation of privacy test.
Which is basically where the court said
It is a search if the police action would invade your reasonable expectation of privacy.
the reasonable expectation of privacy test was formulated in a Supreme Court case in 1967 called Katz v. United States, and it's still a major way that the courts decide whether there's been a Fourth Amendment violation. It was formulated when a judge in the case said that searches trigger a Fourth Amendment protection when
You personally think that you should have privacy in this thing. And that also is a feeling that society is willing to deem objectively reasonable.
this is a terrible test for so many reasons.
Individuals themselves don't necessarily have a fully formed privacy expectation, nor does society at large have a privacy expectation. Take the average Joe or Jane on the street. They don't know that their cell phone is regularly pinging cell towers, so they don't have an expectation about this stuff. So courts have to pull from the air to figure out what we think or what we should think. We've been stuck since 1967, almost 60 years, with a test that asks judges to figure out how we're supposed to feel about information.
And it also seems like this is a shifting baseline, because the more we normalize surveillance in society, the less reasonable it becomes for people to expect privacy.
It's one of their very sound criticisms of the reasonable expectation of privacy test.
But it gets even worse.
After the Katz decision, and after they established this reasonable expectation of privacy, they started to say anything that you revealed to anyone, you lose any Fourth Amendment protection in. I should be able to rely on being able to talk to my doctor or the bank or anything like that.
So you take a bad premise, the third-party doctrine, and try to figure out exceptions to the bad premise using the ever-diminishing reasonable expectation of privacy test, and you're left with a court that is slowly trying to judge every new piece of technology separately to see how they fit into them.
What we see is courts increasingly uncomfortable with those implications of the third-party doctrine. The problem is the court doesn't know how to get out of it, and so it's sort of creating one-off exceptions rather than really grappling with the rule itself.
For example, in the Carpenter case, they created a carve-out for certain cell phone records.
Cell phone service providers have records of where your phone has been, which creates a very strong inference about where you have been. And the question in the Carpenter case was whether the government can get that information without a warrant. But the court said, well, we're not really ready to go with the third-party doctrine here. We're going to say that it is reasonable to expect privacy in this information that reveals your location all day and night, at home, at work, wherever you go, for long periods of time.
They made another carve-out for emails.
One or two appellate cases from like 2010 or so that say, we're going to pretend this email is like a sealed envelope, so you can't get in. So you start to see some pushback by courts against this categorical third-party doctrine approach.
And the result of that is that we see courts litigating every type of tech piecemeal.
Exactly. It's a real challenge for the courts to wrestle with these comprehensive surveillance regimes.
We can't keep slowly litigating every new technology one by one forever. We can't have the courts rule on the one hand that putting a GPS tracker on someone's car to track their location without a warrant is unconstitutional, but allow the police to keep tracking people's location via flock cameras because it's going to take years for the Supreme Court to make a ruling on that specific technology. And by then, we'll have moved on to a new kind of tracking technology anyway. But there is a better way of solving this.
The expectation of privacy on the part of the individual is that it's their data. And I think we really need to revisit the whole scheme that we have here about Americans' expectation of privacy. When these laws were written, there was no cloud. And we ought to extend the Fourth Amendment protections to individuals' data wherever held when there is an expectation of privacy.
First, the government needs to respect contracts that we have with companies when deciding whether we have an expectation of privacy.
If I have a contract with a company and that contract says, hey, I'm going to give you my data and you're not allowed to share it with anyone, and the company agrees to it, they sign it, I sign it, that seems like I should have a reasonable expectation of privacy because we just signed a contract saying you have privacy. And essentially in the digital age, the government says, actually, we don't acknowledge that contract. You have no reasonable expectation of privacy, in that contract with that third party just because it's a third party. That seems insane to me.
Naomi, you're a better Supreme Court justice than many we've seen. It's quite amazing that the third-party doctrine has been allowed to persist as long as it has in the face of contracts, in the face of property rights. And there are privacy policies, yet we can't expect them to have any relevance in Fourth Amendment litigation. That's pretty crazy.
Just ignores the kind of private ordering that we have in our society. And it just says, I don't care. I don't care about that. That has no bearing. And I think that's wrong.
And you know what? This isn't even an issue with the digital age. The third-party doctrine never should have come into existence because people did have a reasonable expectation of privacy in the 70s that their bank records were private, back when this first case was litigated. This whole doctrine was a misstep from the beginning.
At the time, it was fairly clear in people's agreements with banks that their information was to be private. The privacy of financial information has a deep, deep pedigree going back to the founding of the country. But the case was poorly argued, and the court just asserted these things given over to third parties, you can't have a Fourth Amendment interest in. So Miller was convicted, and the third-party doctrine was born.
And Carpenter was no different.
One of the dissents in the case was from Justice Gorsuch, who suggested that Carpenter should have argued property rights. He should have argued a thing called bailment.
Bailment. It's the most important property rights concept that you've never heard of. And it basically solves this whole issue. It addresses the question, who actually owns your data? Bailment is the idea that
someone can hold information for you, and they have to protect it and treat it well, but it's ultimately still yours.
this is obviously how we view data in the digital age. When you give your photos to Google Cloud, they're your photos. You just consider Google to be holding them for you. When you store your files in Microsoft's OneDrive, they're your files that Microsoft is looking after.
When you take your dog to the kennel, the dog is still yours. The kennel's taking care of it. That's a bailment. When you hand your keys to the valet and the valet goes and parks your car, it's still your car. The valet has possession, but it's still yours. That's bailment. We all understand property and tangibles, things that you carry around. We're on the cusp, I think, of recognition that information, and particularly personal information, is a form of property at common law. People own information about themselves, and they lodge it with service providers, and that would preserve the right to contest the government taking it under the Fourth Amendment.
So one thing that we need to do is recognize legally and culturally that our information is still ours, even when a company is holding it for us. Jim has even worked on legislation in New Hampshire to push this exact idea into law. Bill HB 1436
merely would recognize the presumption of bailment when personal information is placed with a service provider, unpublished. The private information that I lodge with the cloud service provider, the email that I send only to my one or two friends and so on and so forth, all of that would be recognized, presumed to be a bailment under New Hampshire state law. The legal recognition that this is our information will protect us and, frankly, third-party service providers from government agents coming to seize information in violation of the Fourth Amendment and without due process.
We should not be afraid to participate in the modern world by interacting with companies because the government has told us that we have to give up all privacy rights to do so.
It implies that I have to live as a hermit. I have to make a decision. I can either keep everything private and I'm subject to protection, or if I expose it, then I somehow lose any protection. And that's not what the framers said.
They said that everyone should have the right to feel secure in their person and things from government intrusion. It shouldn't matter whether we enter into an agreement with a company for our things. It doesn't give the government a right to take them just because they're with a third party.
If we can get recognition of our rights, the individual's rights in information, I think it could lead to a brilliant future. We'll have new ability to traverse this beautiful digital online world and still have our power.
We need the courts to start framing things in terms of data, property rights, and bailment. And we need Congress to step in and remind people that in the Constitution, it says that searches require a warrant.
At the end of the day, what we need is a massive public debate about this that we just haven't really had yet.
I don't want to stop interacting with companies, but I also don't accept that every time I use a bank, an email provider, a cloud service, or an app, I am silently giving the government permission to inspect my life. That is the lie at the heart of the third-party doctrine. It tells us that participating in modern life means surrendering the protections that we're supposed to have against government searches. If we keep building the digital world on that lie, the end point is obvious. A surveillance state where everything about us is searchable by those with the most power. That's not freedom. The third-party doctrine has to go. This video was brought to you by the Ludlow Institute, a nonprofit dedicated to advancing freedom through technology. We are supported entirely by community donations. So if you would like to support this work and help keep this channel free and accessible to more and more people, visit ludlowinstitute.org/donate. I really appreciate every single one of you who supports this channel. It means so much to know there are like-minded people out there who support this cause and who are fighting alongside us. Thank you so much.